Morning. Please be seated. This is the time set for oral argument in Fellers against Bailey. Our cause number is 1CA CV 16-0073. Counsel, as I'm sure you're aware, we have conferenced the case before coming in this morning. We're very familiar with the briefs and the issues, so you can bear that in mind as you begin your presentation. We will be audio and video recorded today, and those recordings will be made available online to the public and for your review. Each side will have 20 minutes this morning for oral argument, and the appellant is free to reserve as much time as you wish, subject to watching your own clock. And with that, if you're prepared, we can begin.
Thank you. I'm Margaret Schweitzer, and I'm appearing today on behalf of the appellants. May it please the Court, Kathy Fellers and Gary Bailey are two beneficiaries of Elkling Living Trust, and they've brought this appeal to request that the Court of Appeals overturn the trial court's judgment to not remove the trustee in this case. The question before the Court is whether the trial court abused its discretion in failing to remove the trustee. The new Arizona Trust Code applies in this case. The trustee accepted his responsibilities in December of 2011. The new code reinforces and clarifies that the rights of beneficiaries and the obligations that fiduciaries have in administering trusts and to trust beneficiaries are strong.
Strong, but to reverse in this case, wouldn't we have to show that removal was required as a matter of law, not merely that we disagreed with the trial court's chosen remedy?
Correct.
Okay.
And it was. The trustee states in his answering brief, in the absence of express findings of fact by the trial court, the appellate court must presume that the court found every controverted issue of fact that was necessary to sustain the judgment, providing that there was evidence in the record to support the same. The keys here are whether the issues were controverted, the findings of fact were controverted. Were they in dispute?
Isn't it more than just whether they're controverted? Doesn't the court also have to go into an analysis of how egregious the violations were?
Materiality?
The materiality.
Yes, materiality is an issue as well. But in this case, the issues of fact, the key issues of fact necessary to uphold the ruling were not controverted.
But the key issues, for example, self-dealing.
Yes.
But if they're self-dealing on a $10 item, is that enough to warrant removal or to mandate removal?
I don't think that the value, the monetary value of a breach of fiduciary duty is the determinant. I think that the court also has to consider whether these are essential fiduciary duties. We don't want Arizona law to say that we're going to determine whether fiduciary duty should be met based upon how much was at issue. That's not the sole measure. It may be part of it.
But if it's part of it, it seems to create a pretty big hurdle for your clients. Again, if we're sitting and just reviewing de novo, we might very well come to a different conclusion. But if it's an abuse of discretion, and if materiality is a determination that the court weighed and said it's material, but it's something that can be remedied through other means, it seems like a pretty tough hurdle to overcome.
Remedied by other means. I would think that the court would have to see whether it was remedied by other means. If there's been 3 years and 8 months between the date of the death of the trustor and the time of trial, and no remedies have been attempted, I think that...
But remedies in terms of if there was self-dealing, for example, with selling property to yourself as the trustee and taking a discount, and that can be remedied. If there's evidence that shows that the sale wasn't for value or that the discount shouldn't have been taken, I understand that still it doesn't take away from the fact that there was a breach of duty, but it does. Materiality and the availability of other ways of addressing a concern seem to be somewhat discretionary with the trial court.
And if the court is going to make those assessments by balancing the question of whether it can be remedied, the court should look to whether it was, and it wasn't. There was no attempt to remedy any of this wrongdoing. Let's focus on the accountings for a moment. The duty to inform and report, that's a fundamental duty. Fiduciaries have to.
But are you saying that hasn't been remedied and accounting has not been provided? That seems
We're
like
now-
a different issue than should the trustee be removed.
The breach of the duty to inform and report should be one of the primary bases upon which a trustee should be removed. If a trustee has issued 5 accountings, as this had prior to trial, and none had been approved by the court accountant, the first 2 in Missouri were erroneous on their face. They were incomplete, and that was admitted in trial. That's your necessary finding of fact, not whether the trustee had justification for that, whether he had excuses. My lawyer told me to do that. I didn't know what I was doing. That's a secondary question. The primary question is, do you have a pattern of failure and refusal to issue an accounting? Now, how we assess materiality of that, that's not going to come down to money. That duty to inform and report is essential for a fiduciary because nothing can move forward.
But is part of your argument that it's a pattern of misconduct? And that seems to be suggest a very discretionary call. If it's a pattern, are you suggesting there's any one thing that necessarily mandated removal as trustee? The court had no discretion and was required simply to remove the trustee.
I'm not saying a court has no discretion, but I'm saying that there are lines. There are lines that must be drawn regarding fiduciary misconduct, and this court went beyond that line.
But that line, it doesn't appear in statute, right? I mean, there's nothing in the new code that says, in this case, on these factual findings, removal is the only remedy.
I thought you were going in a different direction when you said there's no line in the statute. There's no line in the statute regarding whether the failure and refusal to issue an accurate accounting, that the line sits at 3 or that the line sits at 5. That isn't defined.
Well, but that the only remedy is removal also doesn't appear to be defined. If it were, and we can understand why the legislature may not have done this, because if it were and every breach of a duty resulted in automatic removal, no trustee would serve for more than a couple of months, except in the most sterling examples of trustee performance. That would be a destabilizing influence that the legislature may not have wished.
Correct. However, this isn't just every little breach. These are significant duties. The duty to inform and report, the duty to be impartial, the duty to not engage in self-dealing, those are essential fiduciary duties. And when you have, yes, I am arguing that each of those was a material breach, but the removal statute also provides for removal in the event that a trustee has a pattern, it shows a pattern of unwillingness or persistent failure to administer the trust on behalf of the beneficiaries. That's clearly present in this case. So you have the secondary, granted it's discretionary, you have that secondary measure, but certainly in this case the first measure was met as well. The failure to inform and report is so essential to every other function that a fiduciary performs that essentially what will happen if there is no duty, if Arizona decides that 5 bad accountings is okay, that is not basis for...
I don't think that question is at issue, and I don't even think your colleagues on the other side of the room are going to argue that that's okay. Nobody's suggesting that these breaches of duties don't carry remedies. The question is what remedy is the most appropriate and efficient for the case. As I look at this record, I strain to see how, in a mathematical way anyway, this litigation serves your client's interests, because the cost of seeking removal outweighs the cost of any remedy needed to cure these breaches of duty. The court might have recognized that.
And the initial action taken in this case was taken in Missouri. The settler died November 28th, 2011. One of the beneficiaries, one of the 4 beneficiaries that I represent, requested accountings throughout 2013, and no adequate accounting was provided. And so she filed a request in the state of Missouri only for an accounting. She did not request removal. She requested only an accounting. And what was received was, again, incomplete on its face. The statements at the bottom of that accounting, which was actually sort of an inventory, it certainly wasn't accounting, did not give a listing of expenses, fees paid to the fiduciary or the attorneys. And then the appellant beneficiaries and the trustee and Ms. Norris, they proceeded in Missouri and attempted to get more documentation, and it was refused. So actually, my client's goal was efficiency.
I'm not criticizing your client, and that may well have been the goal, but why is it not within the court's discretion to try and keep a dispute like this from eclipsing the value of the trust estate?
I don't know the statute for that. It has eclipsed the value of the estate, and this could have been remedied in the fall of 2013 by simply informing and reporting. That was the resolution, and my clients did not have the power to make that resolution. Only the trustee had that power. He's the only one with the information.
Well, the court had the power to resolve it.
The
It
court
still
had the-
has the power to resolve it by holding the trustee's feet to the fire and saying, you better get an appropriate accounting done,
Correct.
rather than
At the-
pressing on the removal.
Pardon me?
I'm sorry. At this point, would removal even constitute a meaningful remedy, or is the remedy more financial in nature?
Yes, it will constitute a remedy. At this point, and we're talking about events that have occurred since this trial, at this point, the trustee has consumed all of my client's inheritance in litigating. We still do not have an approved accounting. We have gone through a litigation instituted by the trustee to have my clients removed as beneficiaries. We prevailed in that. The court found that there was probable cause to bring this case, and the lower court has stayed discovery on the accounting, which means that we still do not have answers to what the deceased owned.
But when you get those answers, and I'm assuming that the court will work to ensure that you do get those answers, if those answers show that there has been a mismanagement of trust assets, there's going to have to be disgorgement. There are going to be real remedies for your client that result in payment. Isn't that the more critical remedy?
Yes. The question is whether this trustee can do it or whether he will do it. We do have a persistent pattern of failure and refusal to administer this trust on the beneficiary's behalf. He has not been prudent in the management of the trust assets.
The time to remedy those breaches hasn't passed, right? I mean, you may, let's say everything you're saying is absolutely correct. There's still a remedy out there. We're only here talking about removal. We're not talking about whether your client should suffer the financial consequences of any mismanagement. And so your client still has an avenue for relief, even if there's no removal. And that relief can be compelled by the court. Am I incorrect in that?
It can, but so long as we have a fiduciary that fails and refuses to give my clients the information necessary to reach that remedy, my clients will not be able to. Removal is the most efficient response.
Well, that may be that. I may agree with you, but why is the court not able to afford your clients relief for any breaches of duty that the trustee has committed?
I don't know. Perhaps I'm misunderstanding the question.
Well, okay, let me make sure we're clear on it. It sounds to me as if you're saying that without removal, the court will be powerless to remedy the breaches that you cite. Is that your argument?
No, without removal, without removal, this fiduciary will remain in control of the trust and all of the information regarding the trust.
But this trustee will have to ultimately get the court to sign off on a final accounting that will have to presumably address all these issues. And your client's positions, I guess what I'm understanding the question to be is, why can't those issues be addressed as part of that, any argument regarding the final accounting? Say this was improper, we did not get enough information, there was self-dealing, the trustee took money earlier than he should have, therefore we're entitled to something more. The remedy right now of simply removing the trustee doesn't really address, are you entitled to more money? And if it's just a question of now the information is out there, it doesn't seem like the next step is going to be much different if an independent trustee is appointed. To the final accounting has to be signed off by the court after hearing argument from the parties.
That's correct. And we have an unusual situation here because we have a dual track process. We filed a motion for removal, and the trustee opened this separate track that was the petition for approval of final account and distribution. That has been denied repeatedly. It was, the court accountant denied it 3 times before trial, and then the trial court conducted a hearing on that petition for approval of final account about 3 months after this trial and denied the petition. Now we're sitting in a place of stay. The court has stayed all activity regarding the accounting until after the petition, after the appeal, after the petitions for forfeiture have been heard.
Because the trial court doesn't want to say, okay, we're going to continue with the accounting if you're just going to remove the trustee.
So even though we had included the failure to account and the failure to inform in our petition, it was moved to a separate track. And the evidence was presented on that after the court had made a decision regarding removal, had denied removal. And the evidence that was presented in that October 2015 hearing was shocking. But we are in a position of no movement at this point. And because he's stayed discovery, we can't get the information necessary.
The sooner we decide this case, the faster that second track can move on. One way or the other.
Yes, and the result in the second forfeiture action may moot this case. It might. Because if the trustee and Ms. Norris are removed as beneficiaries from the trust, my clients will become the only 2 beneficiaries, and they'll replace the trustee, and they'll be able to demand the information necessary and do investigation into the expenses and so on. So yes, it might. But Arizona, while courts do have discretion, we're asking that Arizona make the statement that, consistent with the new code, that 5 bad accountings should be at least the line. That should be an abuse of discretion. Furthermore, the undisputed act of self-dealing, there was dispute whether it was justified, but there is no dispute as to whether self-dealing occurred here. That, too, should be basis for removing a trustee. Because if a trustee is able to justify and excuse his wrongdoing, all a trustee is going to have to do in Arizona is hire a lawyer and say, my lawyer told me to do this. And he has carte blanche, because that's what the trustee did in this case. He blamed it on his lawyers. I was advised to do this by my lawyers. So that's the escape hatch. If you can hire a lawyer and thereby be relieved of your fiduciary obligations.
Well, the lawyer would have to go along with it.
The trustee testified that he was advised to do these things. Okay. Now, that doesn't relieve him of his fiduciary duties. It doesn't matter who has told you to do something, but that was the justification given. Those aren't the necessary findings of fact. The necessary findings of fact are that these things occurred. That's the standard in the statute. That's the standard that the trustee himself has stated under Escarano versus Kindred Nursing Centers. The necessary findings of fact are that the events occurred. He took these actions. The only disputes were as to whether his justifications and excuses overrode the fact that he did these things. Pardon me?
Can the court consider the fact that that he did proceed through counsel, that he did seek the advice of counsel before doing something?
I think we have,
Assuming counsel got it wrong, doesn't that just create a claim against, perhaps a claim against counsel for aiding a breach of fiduciary duty? But it seems like it's at least a factor that weighs in favor of, in the trustee's favor, if the trustee seeks independent counsel and an attorney tells him or her that what he's proposing to do is okay. Isn't that a factor the court could consider? Understanding that if the advice is just completely wrong, it doesn't justify a breach of duty. But if you're looking at, should I remove this trustee, isn't that at least a factor that you can consider?
sure, but it is only a factor. And when the pattern of justification is that these were mistakes that always benefited the trustee, this was based on advice of counsel that resulted in my breaching my fiduciary duties, those are factors that have to be weighed as well. And I do think that it's an abuse of discretion to instead look at the excuse or the justification as overriding all of the factors. And here we have that pattern, that persistent failure to administer the trust on behalf of the beneficiaries and the trust. So it's only one of many others on the other side of the scale.
Thank you.
Thank
We're
you.
out of time. You're wrong again. I would just point out to those in the courtroom that it appears our signs are wrong. This is Judge Catani. This is Judge Kessler.
I was going to mention that, Your Honor.
We could just move the signs, but we'll do that for the next argument. Or when we come back in, we'll change places.
Good morning. May it please the Court, Andre Merritt of Sachs Tierney on behalf of the trustee of the Oakland Living Trust, James Bailey. I would like to begin by addressing a couple of questions that the Court posed of opposing counsel and a comment that Judge Swan made before getting into the remarks that I prepared. But one of the first questions, Judge Catani, that you asked was whether removal under ARS 14-10-706 is required whenever a trial court finds a breach of trust to have occurred. And the answer is absolutely not. The provision provides expressly that a trial court may remove a trustee if the trial court finds that, among other grounds, there was a breach of trust, a material breach of trust, or there was a persistent failure to administer the trust in the interest of the beneficiaries, or in the case where there are co-trustees, there's a disagreement between the co-trustees such that there's some inertia that the administration of the trust can't fairly
It goes
proceed.
beyond inertia, though. I mean, there are pretty persuasive arguments to be made that on a scale of 1 to 10, that the performance of the trustee here would be a fairly low rating. Wouldn't you agree?
I would imagine that there are trustees who have performed in their role as trustees better than Mr. Bailey did.
I would hope.
And
If he's the high watermark of all trustee performance, then we should really revisit the notion of having trusts as part of the law.
Your Honor, I think that's fair comment.
None of us would accept or tolerate the type of conduct that has gone on in the administration of this trust were we beneficiaries.
Well, that might be the case, Your Honor. And Mr. Bailey, as a farmer and factory worker for Ford and not a professional trustee, would maybe accept that criticism.
I don't think you have to be a professional trustee to know that you don't sell yourself the house without telling anyone. That strikes me as something that probably most people unschooled in the law would intuitively pick up on as not being consistent with the word loyalty.
Maybe, Your Honor. Could be. the record before this court and applying the standard of review, fortunately, doesn't allow this court to substitute its judgment for the trial court and make those conclusions, those legal conclusions that is in fact what the trustee did.
Well,
But is there a question that the trustee sold himself the property
There is no question as to that.
without notifying? I guess there may be a question about whether the beneficiaries were aware of that. Is that your position at this point?
There is no question that the trustee sold the house to himself, his sister, and brother-in-law. There was evidence in the record below that the beneficiaries here, and I would refer to Ms. Fellers and Mr. Bailey as the beneficiaries for ease of reference, that they were aware at least a couple of months before that transaction took place that Mr. Bailey and his sister were going to buy their mother's house.
Being aware it seems like the duty of a fiduciary doesn't that suggest something more, that it's to absolute loyalty to the beneficiaries? Doesn't that suggest giving information as to this is the value of the property, this is how much we think it's worth, if other beneficiaries would like to buy it, here's what we contemplate doing, what do you think? Isn't that what the duties of a fiduciary would contemplate, as opposed to they might be aware that I'm going to sell this to myself? It seems to me the duty of a fiduciary is the duty of complete disclosure and letting people know from the outset, this is the course of action I intend to take.
It very well may be, Judge Catani, and that might be how you or I would function as the trustee. But we have to remember what this case is about.
I'm just wondering isn't that the duty for any trustee to be completely transparent with what's going on, and particularly when it involves something where the trustee may be benefiting, a sale to yourself, and arguably in reducing the amount for whatever reason. So I'm not pitching myself as being the pinnacle of I'm just suggesting that's a standard for anyone who's acting in a fiduciary capacity.
I think it's fair to say that we can expect of trustees to endeavor to do that, to be completely transparent. But where they fail, where they make a mistake, does that necessarily then mean that there was a material breach of trust, and as a result of it, the trial court was required to remove the trustee?
Is there any point in your view where there would be an abuse of discretion? How many abuses would it take for us to be able to conclude that there has been an abuse of discretion?
Well, I don't know that there is some quantum that you can look to say, a failure to provide an accounting 3 months, or providing an accounting 3 months later than it should have been, is not a material breach of trust, but providing an accounting 5 months later than the annual requirement is a material breach of trust. But again,
if the trustee remains in this case and continues performing at the level that he has so far, is there going to be a point at which removal would be justified?
I would say no, Your Honor.
This level of performance is just fine, no matter how many times these instances of, as you refer to them, mistakes occur. He keeps his role.
Well, I would disagree that this level, I don't know what this level of performance is going to continue means.
Politely agreed that this level of performance has not been the highest. Right?
It has not, Your Honor. But with respect to accounting and the administration of the trust, that's all within the probate court's hands now.
Why is that? Is it not the trustee's job to supply the court with the necessary information to...
And the trustee has, as a result of, and of course it's not part of the record here because it's not relevant to any issue appealed from below, but the court has had a evidentiary hearing on the accounting, the result of which the court ordered the trustee to provide some supplemental information. The trustee has done that, and the After the evidentiary hearing and the court's ruling on the accounting issues, various petitions were filed that would affect the ultimate determination of the accounting. The court decided to have rulings on approval of the accounting abide the determination of those petitions. There's no ongoing trust administration right now. The only thing that's left is the bickering that is not, to your point, Judge Swan, cost effective. And if you look at Judge Bassett's comments, I think he made that much clear to the parties at the conclusion of the trial. But there is no ongoing trust administration. This is all within the court's hands, and these parties are left to fight competing petitions, well, no longer competing, but petitions to disinherit either one of them as violations of the no contest clauses contained in the trust. So there's
no final accounting that's been approved, right?
It has not been approved yet, but as a result of the evidentiary hearing on the accounting, the court concluded that there are one or two discrete issues that I still need information from the trustee regarding.
It's not over yet.
Not over yet, but the issue, Judge Kessler, is whether there is potential here for the trustee's poor performance to continue to repeat itself. And the point that I'm trying to make is, no, there's not. There's nothing left for the trustee to perform in connection with the administration after he satisfied the request from the court following the evidentiary hearing on the accounting. But I would be remiss if I didn't take us back to at least what I believe to be the appropriate analysis that this court needs to employ here. We cannot forget that no party requested findings of fact or conclusions of law when this case was tried on the petition for removal of the trustee. And as Judge Bassett indicated expressly in his ruling denying the petition for removal of trustee, because no party requested findings and conclusions, he made none. And under those circumstances, this court need not quarrel with whether or not Judge Bassett should have believed the plaintiff's or the petitioner's evidence or should have believed the trustee's evidence, but instead should concern itself with whether there is any evidence in the record supporting Judge Bassett's judgment. And when the court looks at the record, it has to do that and view that record in the light most supportive of sustaining the judgment. So whether we talk about whether there were 5 late reportings, whether there was self-dealing in purchasing a house, whether or not those things occurred, for purposes of this analysis, doesn't matter. What matters is whether there was evidence in the record to sustain Judge Bassett's apparent determination that none of those things, either in the aggregate or standing alone, rose to a material breach of trust. And this is the record that we have here. The judge made comments indicating that while he may not be terribly crazy about the sale of the house to the trustee, for example, he found it to be fair. Now, what he did was he reserved his concern about the reduction of the purchase price to, or by 6%, to reflect a typical commission that a seller might sell. He decided, and this goes to your materiality question, Judge Katani, he decided that can be dealt with on an accounting basis. That amounts to a $7,000 plus issue with respect to these beneficiaries that can be dealt with in adjusting any beneficiary's interest in the trust, but doesn't rise to the level of materiality to justify removing the trustee. Same thing with respect to the filing or the timeliness of reportings and accountings by the trustee. The record has evidence supporting an apparent conclusion by Judge Bassett that while these accountings were tardy, and while they can be criticized as being incomplete, not very well written, They were provided on an ongoing basis. They were provided with respect to trust assets that within fewer than 5 months following the death of Ms. Oakland were all distributed. By the time, by May of 2012, Ms. Oakland died in November of 2011, all that remained to be distributed and collected as part of the trust estate was the Oakland residence and a protective life insurance IRA. With respect to all of the other assets of the trust that the trustee was aware of, they were collected and distributed to the beneficiaries. A lot of discussion was had at trial about assets that didn't belong to the trust, like certificates of deposit and bank accounts and savings accounts owned by Ms. Norris, one of Ms. Oakland's daughter, and Ms. Oakland as joint tenants with right of survivorship. And of course, Ms. Oakland's interest in those assets extinguished upon her death. So the trial court had sufficient evidence upon which to find that while the accounting, the timing of the accounting was questionable, while there were issues raised about the collection and distribution of trust assets, they didn't rise to the level of materiality. They didn't justify removing the trustee. When this court looks at the record, it should not do so for the purpose of trying to determine whether it would reach a different conclusion than the trial court. The criticisms of the trustee are fair.
Can I ask one question on the survivorship accounts? Was there any suggestion that the trustee had a duty to pursue a claim of undue influence or something, or were those claims, or was it just a claim that even though these are titled this way, sister had an obligation to put them in the trust?
There was, what you described was the argument that was made. These are trust assets, regardless of how they're titled, simply because mom owned them at one time. That was the petitioner's argument. They disregarded completely the nature and the manner in which these assets were titled, and Judge Bassett, on the other hand, paid attention to how those items were titled. He questioned counsel for the petitioners, asking, well, if the lawyers have concluded that these assets are owned as joint tenants with right of survivorship, if the financial institutions where these accounts are maintained or where these certificates of deposit were sold, if they've concluded that these assets are titled joint tenants with right of survivorship, what would be unreasonable on the part of the trustee in agreeing with that? So that evidence was there on the record below, and because that evidence was there on the record below, it supports the trial court's conclusion that the trustee did not commit a material breach of trust. Your Honor, it's not our burden to go through and demonstrate where the evidence was supporting the trial court's judgment. In fact, a party claiming that a trial court abused its discretion has the burden of showing that. Thus far, you've not heard anything from the beneficiaries regarding the absence of evidence in the record. Maybe you will on rebuttal, but the record is nevertheless clear. And if your honors want me to go through with respect to each complaint about the trustee and demonstrate where the evidence is, I'm not suggesting that I'm unwilling to do that. I'm just suggesting that the court should be careful to listen for the...
It seems to me your argument is, assuming there are breaches, the assessment of materiality of the breaches is within the discretion of the trial court.
That's within the discretion of the trial court, and the determination whether there are breaches in the first place is within the discretion of the trial court.
We think there's absolutely a breach of duty, a duty of self-dealing. But even assuming we reach that conclusion, the next step would be an assessment of materiality, and that's something that is obviously something we would defer to the trial court on.
Absolutely, Your Honor. And because of this court's practice of deferring to the trial court, because of the existence of evidence in the record supporting the judgment The trustee respectfully requests that this court affirm the trial court's judgment denying the petition for relief. Thank you.
Thank you. All right, thanks to counsel for both sides for your arguments. This case is now under advisement. We will issue a written decision in due course, and we will stand in recess to allow the next argument to set up.